Hi, welcome back. Here we are at week 4. This week we'll be spending our time discussing contract law. Under this lecture, we'll be dealing and addressing elements of contracts, elements of enforcement of those contracts, remedies for when a breach of contract occurs, and then we'll also be looking at what are typical athletic contracts, those contracts that you will likely encounter as an individual in the sport management profession. Most of this material will be derived from Wong's Chapter 9. So what is a contract? This word is commonly used, thrown around, discussed, especially in the world of sport. So let's give a specific definition to contracts. As the slide states, it's a promise or set of promises between two parties or individuals for which a breach of duty the law gives a remedy, or the performance of which the law in some way recognizes a duty. I promise we'll be making sense of all of that language in the coming slides. Do note, though, that you can return to this slide to remind yourself of the clear definition of what a contract is. When it comes to the terms of a contract, there are 3 required elements: the offer, the acceptance, and the consideration. We will be addressing those specific requirements of each of these elements in detail in the coming slides. There's also elements of enforcement of a contract. Those include legality and capacity. We also will be discussing those particulars in the coming slides. However, it's important to start off so we understand a framework for what the 3 required elements include, as well as those elements of enforcement. And again, I'll be making sense of those as we come up. Let's begin with our first element of a contract. It's the offer. And while this may seem elementary or simple, the offer typically is quite detailed. So first, the offer by definition is a conditional promise to do something or refrain from doing something in the future. Please note, this could be that the offer is asking for a promise to do some type of work or job, as well as refraining from doing, say, work or job for a competitor company. Elements that are typically included in the offer are listed as follows. There has to be the parties involved. That is, who is the offer binding? What 2 parties or persons are involved? Also, the subject matter. What's the details of that matter? That's also detailed in the time and place for which that is to be paid, as well as the terms or the price to be paid. At times, we can describe the offer as the terms of the agreement, or maybe even indeed the terms of the contract. It is in the offer that these specific terms are laid out in great detail. When we talk later about contracts that are specific to athletics, we will spend some time giving some concrete examples to what an offer indeed might look like in this profession. Let's address the second element of a contract. Once an offer has been given, there must be an acceptance. No contract exists until the offeree accepts the offer. No third party can do this. It must be accepted by the one or whom the offer was made to. It's also important to note that there must be action. That is, an acceptance cannot be passive. One cannot accept the terms of an offer by being passive. Instead, that must be active. So we can do that in verbal or in written form. It's also important to note that there are these 2 kinds of acceptances. There's a bilateral contract, and the acceptance is a promise for a promise. We do this all the time when we purchase things in the store, maybe even if we purchase a home. I promise to pay the cost of the home, you're returning to me the home. We also have what's called a unilateral acceptance or a unilateral contract. This is a promise for a performance. For example, this could look like something as LeBron James is promised X amount of dollars for his performance of the game of basketball. He's actually doing something. Sometimes we can even think about this as a service. Also, think about it in this capacity. I promise, or I will give exchange for or money to in return for someone to paint my house. And that way I'm promising someone for a performance that they will do or an action or service they will take. Let's talk a little more about acceptance. How is it that acceptance could be terminated? There are actually 4 ways. First, the offer could be rejected. Plainly, the offer given could be flat out rejected by the person to whom it was offered. There also could be a counter offer. So for example, I offer to pay the painter $5,000 to paint my house. The painter, however, counters and states he will paint my house for $6,000. Therefore, we would have to start over. This also could be terminated by a lapse in time. That's typically designated by the offer. Also, there could be a revocation of the offeree. So for example, if we go back to my discussion about offering the painter to paint my house, I could indeed revoke my offer of offering the painter $5,000 to paint my house because I found a different painter. Also, it's important to note that death or incapacity of either party to the contract could terminate the contract. So what is incapacity? Incapacity could be that most contracts indicate you must be 18 years or older, as well as to be mentally competent. In addition, an individual who is intoxicated or developmentally disabled may also be classified as someone with incapacity. So those are the 4 ways that our acceptance could be terminated. I do want to note that with that first way, that counter offer, this would essentially start the process over again with a new offer. The third and final element of a contract is consideration. Consideration is what each party gets in return for the contractual performance. In addition, it's the exchange of value that binds the parties, or essentially what each gets in return. Please note this can't be considered or under a gift, past performance, or illegal acts. So for example, if there is a contract between 2 individuals for an illegal act, this contract is considered null and void because of the consideration. Finally, in just simple language, the consideration is the this for that, giving one this in exchange for that. And ultimately, that's what each party gets in return for the contract. Let's look at a few examples of consideration. In some ways, we do consideration on a daily basis. So for example, one example of consideration is money for the promise to provide a meal. If you go to, say, Chick-fil-A and promise to provide money, you get a meal in return. In the world of sport, we see this in terms of consideration of money for the promise to provide use of an arena. So we also need to recognize that this can be an act or promise not to act. In the case of our first discussion of acting, we have a promise to pay salary for the work or acts of an employee. That goes back to my previous discussion of LeBron James. LeBron James is paid a salary for his actions or work on the basketball court as an employee of the Los Angeles Lakers. We also could have a promise not to act. So for example, there could be a promise on the contract to release a worker from the contract if the worker agrees not to open a business in the same geographic area for a certain time. This is called forbearance. Some individuals may use language like it's a non-compete clause or discussion in the contract. This essentially says that an employee will not compete against the organization they currently work for by opening up another competitive business. And that is what our notion of forbearance. So this example of consideration asks someone not to act. Our other example of LeBron James clearly asks him to act and work as an employee of the LA Lakers. Those are just a couple examples to help us get our brain around this notion of our third element of a contract, consideration. If you recall back to our third slide, we began by talking about elements of a contract, which we've just gone through. It's our offer, our acceptance, and our consideration. We also addressed two elements of enforcement, and I want to talk a little more at length about that here. I want to start off with that right-hand side, or capacity. As I previously mentioned, a contract cannot be enforced if there is question of incapacity. Therefore, if the individual is under the age of 18, mentally incompetent, have a developmental disability, and or even intoxicated, they can't enter into a contract. Therefore, if those individuals did enter into a contract, we could typically find it null and void. Obviously, I recognize that in our current modern athletic age, we have some professional athletes under the age of 18. Are they indeed entitled to sign a contract? Yes, but typically it has to be done by their legal guardian. Okay, let's talk then about legality. That's what the left-hand side of our slide addresses. Even if an offer, acceptance, and consideration are all valid, remember those are our three elements of a contract cannot be enforced if the underlying transaction is legal. I want to make note of two types of illegalities. These can include things like gambling contacts or contracts with unlicensed professionals. I am well aware that legalization of gambling has begun to sweep across the U.S. It's not legal in all instances, though. Therefore, if gambling is in place, and in some ways it's also illegal through such things as points shaving, those contracts could not be enforced. It's also important to note we have another type of illegality. This is violation of public policy. If the offer, acceptance, and consideration interfere with family relationships or waive tort liability, these contracts may indeed not be enforceable. So make note, there are certain elements that would prevent a contract from being enforced. That is legality and capacity. As with any type of agreement, there can be concerns or issues that arise. And when they do, I have two areas that I want to discuss that will help us address these kind of potential arising issues. First is our payroll evidence rule. While it may look like a lot of information, it's actually a little simpler than it might appear. Our payroll evidence rule prevents litigants from asserting facts that existed before the contract formation and that are inconsistent with or contradict the existing written contract. So, if a contract is fully integrated, the court systems will not hear any evidence pertaining to or any material terms that are not included in that original contract. So an individual can't bring in and add information to that contract and then say it was supposed to have been in the contract. We can also say that when two parties have made a contract for which they have both agreed on it and expressed that in writing, oral or written evidence of antecedent or additional agreements will not be admissible in varying the contract. That is, that written portion or that written agreed upon contract is that which takes precedence. This is a way to protect members or individual parties, in contract negotiations. Another way to address potential uprising issues in contract law is what we call our Statute of Frauds. It requires written contracts in a couple of scenarios. That is, these contracts can't be verbal. So for example, contracts regarding the sale, mortgage, or lease of land or property must be in writing. In addition, contracts that won't be performed within 1 year, maybe contracts that are going to be over a 5-year span, maybe a 10-year span. Those contracts must be in writing. In addition, if we're dealing with goods valued more than $500, we must have a contract. So what does that do? What is this statute of frauds intended to prevent against? Obviously, with verbal contracts, we can have discrepancies. With a written required contract, this ensures that the offer, acceptance, and consideration are in writing and are the agreed upon terms. I'm going to ask us to go back and recall our second slide that provided the definition of contracts. Recall, it states a contract is a promise or set of promises for breach of duty of which the law gives a remedy or the performance of which the law in some way recognizes a duty. So contract law must take into consideration what happens when that contract is breached and or what is broadly a breach of contract. This can simply be defined as a failure to perform a duty imposed under the contract. And this can be on either side. So we can think about the contract breach can be in two ways: total breach, or one of the parties has not fully engaged in specific performance. Let's go back to our LeBron James example. Maybe the LA Lakers are intending to pay LeBron James to play the game of basketball, and LeBron James has decided he's not going to play the game of basketball. That potentially could be a breach of contract because he is no longer doing any of his performance. That would be a total breach. What's a partial breach? One of the parties has engaged in the specific performance, but not to the extent outlined in the contract. Let's go back to our LeBron example. So for example, LeBron's contract states that not only must he play the game of basketball, but he also must attend at least 10 out-of-season practice sessions. So while LeBron may indeed be playing the game of basketball throughout the season, maybe he chooses not to attend those 10 practice sessions in the off-season that are outlined in his contract. In doing that, LeBron could potentially be in partial breach of his contract. So I want you to make note, total breach would be breaching all of the contract. Partial breach would only be breaching portions of the details of that contract. We're going to be talking in our next slide then, how do we remedy or fix when that contract is breached? If a contract is indeed breached, there are three types of remedies. These remedies seek to pay back or make better that breach in that contract. Those three are damages, specific performance, or negative injunction. I'm going to give you more detail on each of these remedies in the coming slides. If a contract is indeed breached, one of the remedies can come in the form of damages, specifically monetary damages. I want to think about this in three ways: expectation interest, reliance interest, and restitution. Let me give an example or use a hypothetical to help us explain this. Let's say hypothetically, LeBron James has decided to accept an offer from Nike to endorse and wear Nike shoes. With this contract in mind, Nike expects to make or derive a certain amount of profit from this contract. If LeBron breaches his contract and decides he's no longer going to wear Nike and no longer endorse Nike, but he's going to endorse a new brand, Nike would seek monetary damages and remedy that contract in the form of expectation interest. That is, LeBron could potentially be liable to pay back the profit they expected to derive from their contract with LeBron. Okay, using that same example, let's talk about reliance interest. This is discussion or monetary damages to pay back the loss suffered by the party. In our example of LeBron James and Nike, Nike starts, or in this scenario, has started to produce shoes specifically for LeBron with LeBron's logo and name on it. Therefore, they have put money and or expenditures in these shoes with the full expectation that LeBron was going to endorse these shoes and wear them. However, if LeBron breaches his contract and decides not to, this reliance interest would cover the damages or the cost incurred by Nike to produce those shoes because they were relying on this contract. Finally, then, our third component would be restitution. This would restore our party or Nike to its prior condition. This would likely mean that LeBron, in our scenario or hypothetical, would have to pay back any money that Nike gave him, in this contract. Okay, that gives us some indication of what type of monetary damages could come into place if a contract was breached. Let's discuss our last two forms of remedies for a breach of contract. First, specific performance. Courts can issue an injunction to order parties to carry out their contractual duties. In the terms of specific performance, this could then require that the individual and/or parties or company that signed the contract would have to continue that specific performance to meet the terms of the contract. Negative injunction is our third type of remedy. This would forbid parties from providing service to any other party outside of the aggrieved party. Let's use a sport example. Let's say, for example, a coach breached their contract and has decided they want to leave your favorite team and go coach at the rival team. A negative injunction would be a remedy to a breach of contract, in that the negative injunction would not allow your coach that coached at your team to go coach for your rival. Therefore, it would prevent them or the coach from providing their services to a party outside of the aggrieved party. I do want to note, though, that we'll talk quite a bit more in the coming slides about contracts you potentially could see in this industry. Obviously, coaching contracts are under typical scrutiny because of the cost and the importance of them. We typically don't see this notion of negative injunction, but it does give us a good example to consider. Okay, we're going to move on now and talk about some contracts you might see. Now that we've addressed the basic of contract law, we're going to spend the remainder of our time looking at common elements of athletic contracts. We'll consider collegiate contracts, professional athlete contracts, as well as coaching contracts. Let's talk about our first type of contract, and I'm going to call that our college contracts. This is where a student athlete becomes or goes into contract with a university in order to play intercollegiate athletics. Those contracts are, just like we've previously talked, have three elements: an offer, an acceptance, and a consideration. National letter intents and the financial aid scholarship make up the contractual agreement between the student athlete and the school that binds, and it binds the school to provide the student athlete with financial aid and a chance to participate in athletics. In exchange for the student athlete's commitment to attend the school and remain eligible to compete in athletics. That national letter of intent is void if the school does not admit the student, or the student does not meet the NCAA initial eligibility requirements, or if no scholarship is offered. It's important to note that one of the cases you could potentially be addressing in this week's case brief is Taylor versus Wake Forest. This case gave us specific court documentation for how this national letter intent and scholarship would play out at universities. Please make note that's an important case, an important decision in case law that has helped give us foundation and framework for college contracts. Let's move on now and talk about some contract elements that you could potentially find in a common professional athlete contract. While this list is not all-encompassing, it does give us a good framework and/or idea of some of the important areas that are covered in a contract for a professional athlete. First, there's that reserve option clause. This standard issue binds the player to a team for a certain number of years. Think about that in terms of the acceptance and/or consideration. There's also this unique skills provisions, and this puts an injunction on a player not letting them play for a rival because the player is invaluable. So for example, maybe LeBron James has a unique skills provision in his contract that he cannot go play for the Clippers after he plays for the Lakers. Hierarchy of contracts is also collective bargaining. It takes into consideration that a collective bargaining unit takes precedence over player contracts. We see this, for example, in the NBA with the NBA Players Association when the collective bargaining happens. Our next collective bargaining agreement we will see is in 2021 for the NBA. Full performance. This indicates that The player must perform for the number of years designated on the contract. It goes back to that notion, obviously, of our reserve option clause. The player is bound to that team for the number of years, and therefore they must perform fully for the designated number of years. Player exclusivity is a common element for professional athletes, and it limits outside activities of players. Say, for example, players may be prohibited from driving motorcycles. This idea is that it will help protect the player. Assignability requires that a player must go to the assigned team traded to. There's also those bonus clauses, and we see these in a number of contracts, that those areas that athletes may receive bonus and incentives. Maybe those are such things like if championships and all-star teams, top rated in your position and the like. Also, one other interesting element that might be available in a professional athlete contract is health regulations. That is, they must adhere to team medical advice and or medical advice given. As the importance of coaches have become at the intercollegiate and professional level, coaches' contracts have become much more convoluted and detailed. Here are some common elements, though, that might be seen in a coach's contract. I won't read all of these as you can see them, but I do want to highlight a couple really important ones. Duties and responsibilities clearly outlines the expectations of the role of a coach. There can also be such things as a reassignment clause. For example, if a coach is terminated but the university wants to reassign that coach to a different position within the university, a reassignment clause may require that the coach do so. There's also compensation clauses along with benefits and incentives. Those types of things deal with your base salary, but also those kind of additional fringe benefits. They could be such things like vehicles, memberships to local country clubs and or social clubs, tickets, maybe tickets to a local professional team, housing, and the like. Bonuses and incentives would be based upon some type of performance. That could be winning of a championship, winning of a conference. It also could be specifically with intercollegiate athletics for coaches who have a high graduation rate. Termination clause is the ground for which it's permissible to fire a coach. Specifically in the world of the intercollegiate athletics, we've seen some very interesting arguments regarding termination clauses. You're also going to see this in your case law that you will be addressing or case briefs that you'll be seeing for this week. Finally, there's those buyout provisions. If the contract is terminated early, this is the amount to be paid to the coach. We also see it in the other direction too. Say, for example, if your coach is going to leave to compete at a rival institution, what must that rival institution pay to buy out the terms of that coach's contract? Well, again, this is not an all-encompassing list. It does give us a really good idea of some common elements and common points of contention in coaches' contracts. Another very common form of sport contracts we see are waivers and releases. These contracts typically are signed before events or activities and absolve organization for liability suffered at the event. We see this in physical activity where individuals are involved in, say, an endurance race or playing at a certain facility. Maybe it's a waiver or a release for an individual to take batting practice at a baseball facility. It's important to note then that this absolves organizations from liability from injuries suffered at the event. It does not, however, permit the organization to be negligent. Please, please, please make the connection back to our tort law and negligence we've discussed. It's important to note that just like any other form of contract, the contract might not have capacity or it may be invalid if it's signed by a minor or that someone is incapacitated. I also want you to think about that waivers and releases are often designated on the back of tickets for professional sports. So for example, if you decided to attend the Houston Astros game this year, on the back of your ticket would be some form of release statement by the Astros warning you of the potential dangers of participating as a fan at this event. And by providing this information, The organization, the Houston Astros, is attempting to absolve themselves from liability suffered at the event. Again, I do want to recall, though, that does not allow the Astros and Minute Maid Park to be negligent. Our final common form of sport contracts are lease agreements. This is an agreement between a facility and a team or sport organization. This happens at all levels. We see it at youth level, a high school level, a collegiate level, as well as a professional level. Just as we saw with our previous contracts, there's three elements. There's an offer, that is, there's a promise to pay for the facility or the use of the facility. Maybe, for example, your intercollegiate athletic team wants to rent out a batting cage facility to practice when weather is inclement. And therefore, there would be an offer or a promise to play at the facility, the batting cage, and there would be then an acceptance. That way there would be funding. There's also that consideration, the terms of the agreement. Again, this happens frequently and often for sporting teams to use specific facilities. We also see this, for example, in instances of professional sports. Technically, the Houston Rockets lease the facility of the Toyota Center from the city of Houston, and in doing so, they pay rent to the facility, as well as make other various agreements regarding maintenance, use, and the like. It's important to note that these types of contracts can again be made at all levels: youth levels, intercollegiate levels, high school levels, and professional levels. Okay, this brings us to our end of our contract discussion. We've gone through a lot of components. We've talked about the elements. We've talked about ways that contracts can be breached. We talked about remedies. We've also addressed several commonly seen sport contracts. Finally, I want to again draw your attention to our case briefs we'll be working on this week. In these case briefs, you will see specific areas of how this contract law has played out and how our court system has ruled and helped continue to shape contract law in the world of sport. That's it for week 4. I will see you next week in week 5.